Good afternoon and welcome to the Proposers Conference for the Los Angeles County Dispute Resolution Program. This Proposers Conference is regarding the request for proposal number CA-25-004, which is released by the Department of Consumer and Business Affairs. So I want to thank you all for joining us today. Before we proceed with the agenda, we'd like to cover some general housekeeping rules. Please mute your microphone and keep your camera off to minimize interruptions and connection issues during the conference. We will allocate time at the end of the presentation for any Q&As that you may have during the session. We want to remind you that we are asking that you submit written questions in the chat feature in order for us to be able to respond to those questions. If we run out of time or do not have any immediate answers, responses will be provided in an addendum published on September 5th. Please note that this conference will be recorded and made available online. Here in our conference room with the Department of Consumer Affairs, we do have the administrative program team. Administrative and program teams to be able to address your concerns. With that said, I will hand it over to our Deputy Director, Rigoberto Reyes.
Thank you, Maritza. Good afternoon, everyone. So glad to see many of you join us. Thank you for your interest in providing mediation services to the businesses and residents of the County of Los Angeles. As you know, the county has over 10 million residents and countless small, medium, and large-sized businesses that need ways to resolve disputes as they come up. And certainly the services you do are essential to getting this help out to our community. As you know, the County of Los Angeles Dispute Resolution Program provides time and cost-effective alternatives for the residents and businesses of Los Angeles County, again, to resolve all kinds of disputes. Over the last few years, the program is now administered by our County Department of Consumer and Business Affairs, and we are very honored to be able to support you in the community to provide the services. Just in general, generally speaking, mediation services include, as you see on the slide, what we refer to as community-based mediations, the court-based mediations that happen on the day of a court hearing, and then mediation that incorporates restorative justice principles. We'll review some of this in a little more detail in case you have questions. One of the objectives and requirements for every county program, and this is in following up with the county's 2024-2030 strategic plan and a number of what we call Board of Supervisors directed priorities, is to ensure that we serve all communities throughout the county in an equitable manner. So as you can see here on the slide, what this means in serving all these communities, especially traditionally underserved populations, includes intentional targeted outreach, education, and engagement with those communities. In order to be effective, we need to do that in a manner that includes language access and is culturally competent. You all know that to provide mediation services to a certain community in a culturally competent manner is a lot more effective than not having that in mind. Equally important is for our services to be accessible during hours and locations that are responsive to the needs of our communities. As you know, many folks work long hours, and sometimes they need to have access during non-traditional or official business hours. So another board-directed priority is immigration, and that concerns understanding that more than a third of the county's population are immigrants, and we also need to be very responsive to the needs of those communities. And within those communities, there is great diversity, including folks coming from all over the world, again, needing the support in order to resolve those disputes. We want to ensure that we promote efficiencies to maximize resources. The funding for this program is limited, and we want to make sure we get the best out of what we can provide. And to do that, the county strategic plan requires that all programs use data and metrics for strategies and outcomes that tell us how we're doing and how we can do better. Central to all the services we do, we want to make sure that we survey our clients to see how we're doing. And again, using those metrics to refine, to change course when needed, to make sure that we are doing a good job. So just specifically in regard to this program, we need to survey clients we serve at least 24 hours after a case is completed, but no later than 10 days to make sure that, again, we know some of the input feedback from them that would help us do better. Very quickly, in regard to invoicing and payments, they are done monthly. We make sure that we do this promptly as we understand that there are challenges with cash flows and the like. We want to make sure that you get paid for the work quickly and accurately. We will require that you submit a monthly list of resolved cases as well as supporting documentation in order for us to meet the requirements to issue payment. This is a cost reimbursement model, and the amounts that we are allowing is up to $1,200 for community-based and restorative justice type of cases, and up to $400 for day of hearing cases. And again, in a second here, we will tell you a little more detail as to what those types of cases are. In regard to case resolutions, we will need the resolution rate monitor in not just monthly, but quarterly, with the intent to see how we're doing, and at the same time be able to support those contracted organizations in areas that they could use the support of our department. Moving to the next slide, again, going a little quicker here. In order to meet those equity principles, ensuring that we serve those communities that need our support most, we have targeted what we define as high needs areas, and we identify those through the use of some tools the county has developed. Specifically, this program requires that we use the county's interactive map for certification and reporting purposes that helps us identify those areas. And obviously, we will have a lot more information once we get into the contracting stage. The services, as I mentioned just a minute ago, need to be accessible. Each grant or each application or awardee eventually has to demonstrate that they have a physical or location or locations in LA County so that they can provide walk-in services during regular business hours, and evening and weekend hours, as I mentioned, are encouraged again to enhance access. Office locations need to be accessible to our residents who may have some handicap disabilities, and avoid any discriminatory interaction based on race, color, national origin, ancestry, religion, sexual orientation, gender identity, age, or disability, or any other areas where the county, state, and federal regulations require that we be accessible. To ensure that our communities learn about the services and know how to have access to them in an equitable manner, we are going to be very intentional about outreach and engagement in our communities. So minimally, we want to have each awardee host participate in at least one outreach event quarterly, if not more, that we could support as well. Additionally, we would need for the awardees to work with our department on event outreach strategies, materials, promotion. We have extensive experience given the variety of services we offer in the department through worker protections, housing, immigrant affairs, empower consumer financial empowerment. And so we have learned some strategies that I think would support us in this mediation program to reach those communities that need our services. Now here we have this slide where we have a couple of bullet points each in regard to those type of cases we mentioned earlier. So the community-based cases, as many of you know, involve services related to individuals, families, businesses, organizations, and many others, and could include hybrid and virtual mediations, including Superior Court, LA, or DR cases. These are primarily cases where you would see someone in the community coming, asking for help with some dispute, either a neighbor to neighbor, a consumer who has a problem with a business, or a business against another business, all kinds of disputes that are in the community and not in the court process. In regard to restorative justice cases, as you can see here, these bullet points are just, again, high level for us to identify those. They require a referral and authorization from a law enforcement or prosecuting agency. It has to be, if it's a pre-filing stage, pre-filing in court, it has to be uncharged or no case number. And if it's post-filing that you're providing the service, then obviously it would have to be charged, and there has to be an active case that would have a case number associated to it. In moving through the case process, the organization, the service provider, has to secure and maintain a written waiver signed by the offender that has to be on file in order for any future audit or any need for us to have access to that level of documentation. In regard to the day of hearing cases, that's pretty straightforward. It is to initiate or resolve cases in core locations throughout the county. And remember, this all has to be in the county of Los Angeles, that will be up for under $35,000. And part of this service, receiving funding for this service, requires that the service provider have in-person services at least 2 days per week in the designated courts that they have proposed to serve. As you know, it is very important to create goodwill and support from volunteer participation. We are asking that at least 10% of the work and the support provided through the organization be done by volunteers. That means that one out of 100% of the work for that month, at least 10% will have to have been done by volunteers. In one area that the county has identified as high priority in terms of equity is access through language capacity. In fact, the board adopted a countywide language access policy that applies to all county departments. It applies to all county contractors. And so it includes having a multilingual workforce that is responsive to the county threshold languages. We can provide a list of what those are, and the capacity to provide interpreting and translation services in those languages that our residents need. Another thing that the policy requires is to have a language access complaint system where our clients can report issues when they come across challenges in regard to language access. So keep in mind that having that capacity is vital for us to be able to serve the diverse needs of the residents in the county. And again, this is throughout the county because that's what this program intends to serve. The next slide here is just some additional information that we want to share with you now. Some of this obviously will require a lot more discussion during the contract negotiations upon receiving applications. But just quickly in regard to training and staff and volunteers, again, this is applying the lens that we need to have equity built into all the things we do. So we want to learn from you for you to provide us at least 30 days advance notice when you are going to be doing a training, including the schedule and the location. Certainly we want to encourage collaboration among different service providers, and when possible, want to share the opportunity when there's some good training that you are providing that others could participate. And that would apply for us, the internal program that we have here in the department, that we will let you know anytime that we're going to be conducting some training in case you're interested in either sending someone to get a refresher on their previous training or just go through whatever we are providing. We will need to have a list of trained individuals who are willing to be included in a county-wide DRP pool of trained neutrals, and it would be very useful if we know what language capacity those volunteers have and whether they are willing to volunteer with somebody else upon request. Two more bullet points here on this access to justice cases. Again, the defendant is to be encouraged to consult with a public defender, private counsel prior to services being provided, and the defendant is informed of the right to counsel and waives their rights. Lastly, and this is my last bullet point, it's just very general. As with any services, we need to make sure that all services provided must be in accordance with the California Dispute Resolution Act of 1986 that lays out what services are eligible for funding under these fees that the state collects and distributes to the county to provide these services. And as a reminder that it is and will be the program service provider's responsibility to understand what those regulations are, and certainly we will serve our support in understanding that. So I believe at this point, I'm going to stop here and I'm going to turn it over to our administration team to walk us through the rest of some of the details that I'm sure you want to hear about.
Okay. Thanks, everyone. Before we go over some important dates, I just want to provide a gentle reminder that any questions or matters related to the solicitation must be submitted in writing only to the designated contact that is listed in the solicitation. I have the email listed on the slide, but you can also find the information in section 1 of the RFP and section 6.2. Some important dates to know is that any written questions are due today by 5 p.m. Anything submitted after that won't be posted with the response or may be answered through the addendum. The Q&A will be released through an addendum on September 5th, and proposals are due on September 13th by 2 p.m. Just want to reiterate that 2 p.m. is the deadline. Anything submitted past that won't be considered. So please make sure you give yourself sufficient time to submit the proposal. We're really strict on the deadline with the time. So even if we receive it at 2:01, the proposal won't be considered. The minimal qualifications to note, this is found on section 4 of the solicitation, is that the proposer must not have any unresolved question costs identified by the auditor controller in the amount over 100,000. The proposal, once again, must be submitted by the deadline. The proposer must provide a minimum of 3 references, and they must have a minimum of 3 consecutive years experience within the immediate past 5 years providing alternative dispute resolution services. You must also have a physical office location within LA County, and you must have cash reserves equivalent to the cost of operating the proposed DRP services for 2 months. We anticipate the contract to be or term to begin on January 1st, 2025. The initial term will be for 1.5 years, and there will be 3 one-year optional extensions. Required forms will be found in Appendix B, and they're just relisted here for you to take a quick look. Submission instructions are relisted here, but are also found in the solicitation under section 8.4. All submissions must be submitted electronically as a single PDF file. There is a page limit. I believe it's 35 pages. And please note that the required forms that are listed, well, required forms 1 through 11 won't count against the page count. Neither will any financial statement documents that are submitted. Please make sure you include the proposal for LA County Dispute Resolution Program Services and the RFP number in the subject line when submitting your proposals. And moving on to the sample contract, the only thing to note is that this will outline the county standard terms and conditions. These are generally non-negotiable. However, respondents who would like to propose any exceptions to the terms and conditions must follow the instructions on the RFP to submit any proposed changes as part of their proposal. You can find these instructions in subsection 8.5.4 of the solicitation. And if you have any exceptions to the statement of work as well, this is the section that will provide instructions on how to submit those red lines. Just to note, the county may in its sole determination disqualify any proposer with whom the county cannot satisfactorily negotiate a contract. Just to provide a general overview of the next steps, the Q&A addendum will be released September 5th. Following that, the proposals will be due. So we'll be receiving submissions on September 13th. And then all proposals who meet the minimum requirements will be evaluated. From there, we'll go through the selection process and notification. Proposers who are selected or are not selected, both will be notified. Within that letter, you will be provided either next steps or information on next steps to conduct a debrief or hold contract negotiations. Key takeaways, just want to reiterate that the deadline to submit questions is today by 5 p.m. Please submit all your questions to contracts@dcba.lacounty.gov. And proposals are due on September 13th by 2 p.m. Late or incomplete submissions will not be considered, and this is no exception.
Thank you, Sarah. So I think we have a lot of questions on the chat menu. What we'll do is maybe start from the top and go through the questions. For those that we have answers readily available, we can provide that on this call. Some of them may require us to go back and provide you a written response, which will be included in the addendum Sarah mentioned a few minutes ago, and will be posted when? September 3rd?
September
5th. So the first question is, what data does the county have for the past programs? How many served in each categories? What was the cost? What was the time for resolution? Not quite sure how this is relevant to the current RFP and the upcoming program. So we'll have to go back and maybe seek some advice and provide a written response to you at a later time on this. Is there a limit on the number of fringe benefit rate can be charged against the grant? We understand fringe benefits vary from organization to organization. As long as it's the actual benefits being billed to us, then we have not placed any limitations on fringe benefits in the past. So the answer to that is no, as long as it's actual cost of the fringe benefits that is being billed to us. What are the past resolution rates for each category and what was the cost reimbursement history? Same as for the first question. We'll have to get back to you in writing as part of the addendum on this. Next question, does the grant allow for a flat rate charge for administrative and indirect costs rather than having to itemize out the items on the budget forms such as utilities, janitorial maintenance, etc.? If a flat rate of indirect cost is allowed, what is the limit on this rate? Without going into too much detail as to the difference between administrative and indirect costs, I'm going to break this question into two pieces. Indirect costs are allowable up to the de minimis rate of 10%, which I believe the feds will increase to 15%. I just don't know. I don't recall when, but it's up to the de minimis rate established by the feds, or if you have a federally approved indirect rate. For which we would need the actual approval notice from the federal agency. Administrative costs can be direct costs. If you are choosing to charge those directly to the program, then yes, they would have to be listed separately as separate line items in the budget and in your invoices. If you are going to charge us indirectly, then those administrative costs will have to be rolled into your indirect cost rate. Next question. what data is available on how many and when it fills and when were received weekends. As I think we've had a couple of other questions similar to the current program and the past program stats. Well, we'll get back to you on this later, please. Business hours limited to 8 a.m. to 5 p.m. or can our normal hours are from 9 to 6?
So the current contract indicates that normal business hours are from 8 a.m. to 5 p.m. or as agreed upon by the county manager.
So at the time of contract negotiations, I think that's something that we could.
Absolutely. And remember, the business hours are to be as responsive as possible to the needs of the clients we serve, right? So if we can see that 9 to 6 is more responsive than 8 to 5, absolutely. So it's flexible depending on the clients who need your services.
So the next question is seeking clarification in various areas within the RFP. Not having the RFP in front of me per se to reference those sections, we will provide you a written response to those questions at a later time. Unless you, Sarah, you have an answer, right? Okay.
I do.
Okay.
So to clarify section 3.4.1 and 3.4.2, we made the initial term for a year and a half because we're working off of our fiscal year which is from July to June. So the funding for the initial 6 months will be for that fiscal year. And then we'll provide the amount that's granted at the next fiscal year, but that won't have anything to do with the term of the contract.
I see. So it's an 18-month contract for the initial term. The first allocation will be for 6 months at 1.1 million. And then the second allocation will be for the following 12 months at 2.2 million, giving the term of 18 months.
Yeah.
Okay. And then with optional 1-year extensions thereafter for up to 3 years.
Yes, also given the availability of funding.
Okay, perfect. We have a question for the next one too, or no? So for 2, 3, and 4, we'll get back to them. Yes. I think our outreach programs separately funded, how much county support is provided. Outreach costs are part of your budget and allocation. So no, they are not separately funded. You would have to budget for those out of the funding that you receive from the county. I assume that how much county support is provided. By support, you mean monetary support, and I think I just covered that. What has the past experience been? Again, anything related to the past financial data or program data, we'll get back to you in writing. I don't see how that's relevant to the RFP. Is the grant cost reimbursement based on, or will the invoices be paid on or per case resolved basis? The cost reimbursement is based on actual costs. So you will bill us on a monthly basis based on actual costs, which will then be reconciled with the number of cases being resolved. If the county identifies that performance is not being met, meaning that your invoiced amounts are exceeding the cap or the agreed amount per resolved case, then we will address that and the terms stipulated in the contract under non-compliance of performance. But it's a cost reimbursement. You will be billing us and be reimbursed for your actual costs. So I think they on case, yes. And the resolved cases will be used to reconcile those costs to ensure that you stay within your limits. If applying for community-based services, can applicants specialize in one of the categories, for example, families, or is it required that providers must serve all categories, business, neighbors, etc.?
So that it is not required. what we're going to do in reviewing all the applications that come, collectively, we have to be responsive to serving the needs of all residents and businesses throughout the county. So in selecting the applicants that will receive the funds, we have to make sure that we meet or get close to that goal. So, certainly if you serve one demographic, that doesn't exclude you from applying and receiving services, as long as collectively we meet the goal of serving all. I hope that answers your question, but that's how we're looking at this. The collective delivery of services through individual participants.
Thank you, Rigo. I think the next question is also related to program. When documenting time for mediations, you requested we only document time providing the mediation conciliation session. How do you want us to document staffing time for volunteer participation? I think this is something that we can discuss once we're ready to execute contracts. It's more on the reporting side once the program is wrapped up and implemented. How many different languages are required? What languages are required?
So the county has a number of languages that we see as a threshold. It varies actually depending on what department and what services are being provided. For instance, the Register Recorder's Office has a certain number of languages that by federal law, those voting documents have to be provided in. We will provide a list of those languages as we move forward as part of this process. But for now, if you could tell us what languages you serve, because the county has identified the major languages, and then we also need to be responsive to languages that, while the number of residents who speak that language may be small, the need to serve those residents is very high. Like, for instance, some API languages, some indigenous languages that the speakers of those languages traditionally haven't been served, and we are being very intentional in making sure that through this program we are as equitable and accessible as possible.
Thank you, Rigo. The next question reads, the required forms package is 24 pages. Required attachments will constitute at least another 8 to 10 pages. The total proposal package limitation is 35 pages. Only financials and support letters exempt from the page count. These factors leave essentially no room for completion of any narrative responses. Will the county review this and reconsider the solicitation page limitations? I'm going to let Sarah respond to this because I think she kind of touched upon that when we were looking at the required forms.
Yes, so that was covered on the required forms, as far as number 1 through 11 won't count against the page limit. Financials and support letters are also exempt from the page count. So page count will only consist of the business proposal and the cost proposal.
I hope this that should give plenty of, yeah. Okay. All right, next question regarding walk-in access. If an applicant is applying to provide services in multiple supervisorial districts and already has an office for walk-ins in one district, are they required to have walk-in locations in each district they are applying to serve? Good question.
So while it's not required that the provider have physical locations in every district, it certainly would be desirable. Again, residents, say for instance, in Lancaster, will have a challenge coming to an office in downtown. And if an applicant has an office up there, then that obviously is a very positive thing. But then again, collectively, we are going to look at making sure that we cover the entire county. So I would not hesitate to apply if I only have one physical location, say in Long Beach. Send the application, and then we're going to have to go through what we want to accomplish in totality, and that's how we're going to make the selections.
Great. Next, I think it's in line with the previous questions. Are exhibits excluded from the solicitation page limit? The answer is yes. Do we want one PDF form?
Yes.
Yes. Do providers need to be nonprofits? No. Is the required redacted PDF to be provided as a separate document along with the proposal submission? Do we need clarification on what they mean by redacted PDF?
Yes.
If you can please provide more clarity on your question, please just type clarity via typing at the bottom of the chat menu, and we'll get back to that. What is the significance of the highlighted terms in the sample contract? We'll have to take a look at that. We're not sure what was highlighted at the moment, so we'll provide a written response to that. Is the required redacted PDF to be submitted as a separate? I think it's the same question. So if you can please provide clarification on what redacted PDF is being referenced to. And everything is a single PDF file. When bidding for a supervisorial district, must you bid for all court locations within that SD, or can a selection be made?
You don't have to bid for all courts, but then again, collectively, we're going to have to see how we're going to provide services throughout the county.
What is the time frame for a protest, which is specifically related to the time frame? Do we have an answer, Sarah, or do we
For
need
the
to?
SSR, yes, it should be outlined in section 1 of the solicitation. So if it's for the SSR, it's specifically listed there. For any protests, like after the evaluation process, that'll be provided in the letters provided to anyone that any respondents.
Yes, so the process for the protest and the timelines will be included in the letters that the applicants receive, informing them of, whether they're qualified or not, or selected. No budget template is provided in the package. Is the county asking that a combined budget justification are entered into the form field on Exhibit 13?
Yes, so anything related to the cost proposal will be a response, or we'll provide a response on Exhibit 13.
Thank you, Sarah. Can the cost of the county required background checks be included in the budget? Good question. I think when the answer is yes, it's a county related cost for the program. That they can include it in the budget. What is the process should an independent outside review of a protest be required regarding the timeframes and process favoring incumbents and disadvantaging innovation? So, again, timeframes in terms of the protests will be included in the letters that you receive. This question was skipped above. Sorry if we skipped it. Regarding the 10% volunteer requirement, can that be on parts of the work that are not mediation? There are strict labor laws that require that a particular job cannot be partially done by volunteers and partially by staff. So if some mediators are trained, they basically need to be paid. This would necessitate that volunteer roles cover other duties that are not staff duties.
As long as the volunteer support work is related to that workload resolution, it would be eligible, but there has to be a way to demonstrate that that is the case.
Thank you. I think the question on the redacted PDF is reposted with clarity, Sarah. Proposers must also include a redacted business proposal and searchable Adobe portable document with all confidential, proprietary, and trade secret information redacted as part of its proposal submission. With respect to this requirement, proposer must submit one electronic copy and searchable PDF, confidential, proprietary, and trade secret information redacted.
I think because any proposals that are submitted, they become public information. So if you submit any proprietary or confidential information in your proposal, you want to mark that and provide a separate PDF that can be used if in the event that there is a public information.
So does that mean that in some instances, multiple PDF documents can be submitted as part of the proposals? Let's think about it and maybe
Okay.
provide a written response.
Yeah.
When can we access the recording?
That should be posted along with the Q&A addendum, September 5th.
Okay. Is it the case that an SSR protest was due August 23rd?
Correct.
Okay. I do not see any further questions in the chat menu. They do have until the end of today,
Yeah.
5 p.m. to submit questions to the email address that was included in the RFP. If you do have questions, please go ahead and submit. Another one came in, so a redacted PDF may not actually be required if no information is considered a trade secret, or I think the answer is.
That's correct. It's just up to the organization. Sometimes they want to label their financial documents as confidential. So that's where you'd want to mark that information as such.
Thank you. What is meant by the match contribution is the non-federal share of funding provided by sub-recipients to support program administration. We'll provide a written response to that.
Right. The next one there, our joint trainings is permitted. Not only are they permitted, they are encouraged. I think it's really great if we can train staff throughout for some uniformity and certainly collaboration that would lead us to greater results.
Another question came in, if invoices will be paid based on cases resolved, how do we get paid for the training of neutrals and outreach we are doing? I think previously we mentioned that these will be cost reimbursement contract where you will be reimbursed for your actual costs up to the negotiated amount in your contract, which cannot exceed $1,200. Any costs associated with you resolving a case can be included in that invoice, including training or outreach. And then the actual costs will be reconciled against the number of resolved cases and the up to amount that will be negotiated and included in your contract. Someone posted this question and I haven't heard a response. Is it the case that an asset was due? Yes, the answer to that question was yes. It was due on the 23rd. This is a question from a partner whose chat isn't working. RFP section 3.4.5 days of operation. The section states subrecipients will be required to provide dispute resolution services in a physical office location. Would appear to indicate in-person sessions only. However, 3.4.6 states new technologies may be applied to in-person, virtual, or hybrid mediation sessions, which seems to imply virtual sessions are okay. Can subrecipients conduct virtual mediation and or restorative justice panel sessions?
The answer is yes. One is not exclusive of the other. If you do virtual or some sort of a hybrid, that will be permissible, but the organization has to have a physical location for walk-ins as well.
Will we receive the written answers to the above questions? I believe if we verbally responded to them, they'll be in the recording. We'll provide a written response to questions that we were not able to respond, but we'll go back and consult with our counsel just to be sure. Next question, section 8.5.1.15, proposers pending litigation and judgments, page 24. If the subrecipient is a government agency with volumes, ongoing criminal, municipal, and civil litigation that are within the course and scope of doing its day-to-day business, such as the LA City Attorney's Office, will it suffice to list the pending litigation and judgments as it relates only to the proposed subrecipient program, such as naming any pending litigation and judgments involving only the dispute resolution program for LA City's Attorney's Office? For reference, in the 2019 application, it was allowed to list the litigation and judgment against the program itself only. I don't know if
I think we need to get back with that.
Okay, thanks. I would think the same for the following two questions related to sections 8.5.1.3 and 8.5.1.4.
That's correct.
And the appendix B. Can you please clarify whether the declaration is a declaration connected to exhibit 10 or is it a declaration on its own? I think we need to look at that. So we'll provide a written response to this, please. Form 10, lobbying, disbarment, etc., has no signature line. The signature on Form 11 declaration satisfy the execution required.
Yes, so the declaration signature form exhibit 11 is for all of the forms above, so 1 through 10.
I do not see any other questions. Give you guys some time if you see if you have any. Well, this is gonna be a big milestone, I think, for all of us getting into the new program year, contract year. So we do accept questions until 5 p.m. today. We'll provide written responses to them all and post them. Best of luck to all of you. Hope we could work with all of you, but limited funding wouldn't allow us to. So thank you all. And if there are any further questions, please send them in before 5 p.m. today, please.
There's just one effort, the word will recording in PowerPoint be accessible and when?
So it'll be made accessible on September 5th along with the addendum. And it should be available on the same page where you find the solicitation documents. So on the doing business with LA County website or through, yeah, that's the one, sorry. Yeah.
There's one more. Is the funding amount per district supposed to cover all 3 service types? The answer, again, the goal is to be equitable throughout the county with all services, but we understand that there are limitations. For instance, courthouses in one district may be more viable and accessible than some others. So do not refrain from applying. If you can serve only one area, again, we will look at all the applicants and together we will see how we can provide the best coverage throughout the county with the available resources.
Thank you, Rigo. We'll hang on for a couple of more minutes, just in case things pop up, guys. But if you don't have other questions, you're free to leave.
Absolutely, yes.
Is the 1 million funding for 1.5 years the total amount available for DRP program as a whole? So the total available for a 12-month period is 2.2. The 1.1 that you saw earlier was for the first 6 months, starting in January through June. And then it will be 2.2 million thereafter from July through June. To try to be more clear on that last question, the county has a budget of 220,000 per soup district. Does that mean the county will try to fund services for court, community, and RJ in that district for that total?
The answer is yes.
Next question, and can the trainings also be training workshops to help the community deal with disputes and not have them escalate to lawsuits? Or do they have to be the full mediation certification training only?
Yes, this we need to think through. I'm thinking this will have to relate to the certification of the training if you're referring to volunteers or staff that will be providing mediations. But if by trainings you mean, say, for instance, a community workshop for community members to prevent disputes from escalating, then that could count against the community outreach and engagement. So we'll look at the question and provide a clearer definition as to either way what that means.
Another question says, I note that we are aware that chat function was not accessible to certain individuals. I don't think it's any thing related on our end, that maybe technical issues that they were having or not updated software or whatnot. I don't know how to address that. But thank you, Tom. So applicants may consider requesting the full amount in their SDs. No maximums are stated in the RFP, only a minimum request of 100,000. Yes.
Yes, the answer is yes.
Welcome, will stay on, guys. Should the business financial proposal only be focused on the first 1.5 years contract if the funding amount is different for the later years? Your proposals are for the 1.5 years, correct, Sarah? Yes, the proposals are for the 1.5 years. Are we at? And then if the terms of the contract are extended, exercising the options to extend, then it will be prorated based on the extension period. The proposal instructions ask for budget for first 6 months.
Yeah, so since we only provided the amount that will be funded through the program for the first 6 months, we only asked you to provide the services that you can provide with that given information for funding.
So then going back to the previous question that's asked if the business financial proposal should be focused on 1.5 years. Does that mean it should be only focused on 6 months?
For the funding, yes. Yeah, and then if there's any changes down the line with the services, then that's done at a later point when we're discussing the contract and executing.
So just to eliminate any confusion, what we'll do is we'll provide a written response to the question related to the first 1.5 years and clarification on the 6-month budget ask in the proposal. Next question says, for the 10% volunteer hours, does that have to be 10% of each month, or should it be at the end of the fiscal year? We have seasons that are some volunteers heavy, some that are more volunteer heavy. So an annual 10% would be more helpful at the end of the fiscal year.
That is a good question, and we understand that there could be fluctuation month to month. We want to make sure that we stay on track with all aspects of the program. So this, we would encourage to stay up to the 10% monthly, but at least quarterly. And we can provide a more specific response, but if we wait until the end of the year and we fell behind, it's impossible to catch up. So we would monitor at least quarterly to make sure that we are moving along pretty well.
So service goals and budget calculations should only be in the initial 6-month period. We'll provide a written response to that. We're actually, what we'll do is, while we wait on, other questions, if we are able to find a response to that, we will. Yeah, 6 months? Yes, we just confirmed. It is for 6 months. But we'll also put it in writing for you guys. I just didn't want you to wait until September 8th, which kind of eats up into your time to submit the proposal. So it is for 6 months. Quarterly check-ins are reasonable for the 10%. Thank you. We lost 2 more attendees in the last 10 minutes. We got 16 left. Does that count include us? Some of us? 15. 1, 2, 3, I think 5 of us.
If we're logged in. We are.
Thanks. So just to confirm, service goals and budget calculations and proposal are for the first 6 months.
We have the dates listed on the cost proposal, so it would be for the initial 6-month period, January 1st, 2025 through June 30th, 2025.
Thank you, Sarah. 6 months. If we get no more questions, guys, we'll kind of sign off at 1:15. And if you come up with any questions, feel free to email us. I was telling the team that we went down to only 14 attendees, and I think 4 of those are us. Thank you for attending. This is a big one. Program enhancement, new technology. Subrecipients will be expected to enhance. I think that's from the bank questions. What are you asking for if a proposer already embraces technology and uses it to improve its outcome, services, and evaluation? We have a list of preferred technology, the definition of a measurement, standard be part of the project monitoring response time. Let us provide you a written response to that. That's a heavy question, just so we don't create further confusion, and it'll give us a chance to kind of dissect the question, please. How does the application process change if an applicant wants to use a subcontractor? I don't understand the question. Do we need clarity, or we understand? I don't understand the question because I don't know what. Sarah's the brains behind the call, so she knows what you mean. We'll give you a response on that, please. Do they need to provide all the same info for this? Got it. We'll let you know in writing. Any other questions, folks? Well, thank you for attending. We're going to wrap it up. And like I mentioned earlier, if you come up with other questions, please feel free to email them. we'll go ahead and go through the recording, identify questions for which we did not provide responses, and include that in our Q&A as part of the addendum, and have those posted on September 5th. Sorry. Thank you again for attending, and hope you all have a great afternoon.